application to revoke or an application to accelerate in Oklahoma law? I am Stuart Erickson, Wagner attorney. After a plea deal of probation in Oklahoma, there's two types of probation. There's a suspended sentence, will you be on probation, or a deferred sentence when you're on probation. And let's just say you're serving a 5-year probationary sentence. So 5 years you're on probation. An application to revoke is to revoke a suspended sentence. Now, a suspended sentence is a permanent conviction on your record. A deferred sentence is where the judge defers sentencing for that 5 years. At the end of 5 years, if you do everything right, the judge will come back, dismiss, and expunge that case. But now, an application to revoke or accelerate is when a person violates their probation, either by committing a new crime or by violating a technical part of your probation, like not paying your fines and costs with the clerk's office. If you're supposed to go get a drug and alcohol evaluation and follow those recommendations, if you fail to do that, the DA's office will file an application and basically say, go back to the judge and say, Judge, this defendant has violated their probation. We want them to go to prison, or we want some sort of sanction or something like that. So when an application is filed, you are entitled to a hearing. Again, it's not a jury trial, though. It'd only be to the judge. The state would have to prove that you violated your probation, either by putting on evidence of a new crime you committed or by simply calling your probation officer. And maybe the probation officer just testifies he's failed to report in person, or she's failed to report in person. That's a violation. Now, as your defense attorney, many times what can be done, especially for technical violations, is to stipulate. Like, let's say you've just failed to report and you have some reasons, but the person ignored it. So as your attorney, I would try to get the DA's office to agree and say, hey, we agree we have failed to report, but hold off on this application. Let us get back into compliance. We will report. And let's say 6 months, let's hold this off for 6 months, let my client prove that they can report. And so after 6 months, if you've reported, then that application can be dismissed. Now, if there's just a complete failure, again, let's say it's a 5-year suspended sentence, that is a conviction. So if the state were to prove that you violated it and the judge says, yeah, you're not fit for probation any longer, the judge could sentence you to 5 years in prison or less, anywhere up to 5. So that is how that